Good morning, everyone. Welcome to the First District Court of Appeals. We have two cases up for argument today. I'll read off the cases, and if the attorneys could please identify themselves and their readiness to proceed. The first case on the docket is case number C-22-0494, State of Ohio versus Stevens.
Good morning, Your Honor. John Boat on behalf of the appellate city of Cincinnati. I'm ready to proceed. I don't believe Mr. McCoy from Mr. Stevens is present at this time.
Okay, I think he's on his way, I've been told. So if that's the case, we're going to have to start with our second case on the docket, if that's all right with everyone. The second case is C-23-0001, and it's Bauer versus River City Mortgage.
Richard Haber on behalf of the appellant, Ms. Bauer, and I'm ready to proceed.
Okay.
Tim Owens on behalf of the appellees, I'm ready to proceed.
Okay, well, if both of you could please come forward, we'll start with that case, and then hopefully Mr. Stevens will show up. So we'll go ahead and proceed with.
Mr. White just walked in.
Hello. Okay, then we will start with the State versus Stevens. Well, please come forward. Sorry, I was calling you Mr. Stevens. That is the appellant. You are Mr. Hoyt. Would you like to reserve some time for rebuttal?
Not really,
Okay.
How much time we got?
You have 15 minutes.
15 minutes?
So you don't want to reserve any time?
3 minutes.
3 minutes? Okay. There's lights on the podium. The green light means go, yellow means you have a minute left of your initial time, and red means stop. So whenever you're ready.
Okay. Thank you, Your Honor. Sorry for being late. The bridge is unpredictable. Yes. Here on of course you know what we're here for, the appeal for it's actually an M3 violation of the zoning code. Just as a sidelight, there's always some backstory that you don't get sometimes, I guess. But Otis has been in this neighborhood for, again, back in the 70s, 80s, I don't know which. There's a corner on a Vine, and I think there's like 4 buildings together there, 1701 through 1707, something like that. And horrible state of repair, but he's been working on it. And behind, you got these 3 buildings kind of, and behind that is this contractor storage yard, we called it, okay? The state doesn't like to call it that, but that yard had fence. It was not that visible, but the state, they even had to climb over things in order to get pictures and stuff like that. And Otis had, I think he presented at trial. I wasn't the trial attorney, and I must point out that he didn't have, the trial went on, it was a visiting judge, and then it was set over for a sentencing. And Otis had a lot of medical problems, cancer problems, et cetera. And so I know the state made a big deal about his capias is in the in their brief. But Otis had and then they had the sentencing. And at the sentencing, he thought he had an attorney, but evidently the attorney had withdrawn during this process of waiting on the sentencing, and him caping.
So he was sentenced and then he served his sentence and got
Yeah.
early release.
Yeah, I did a motion. I stepped in the case
Right.
after they sentenced him,
Right.
and he served 2 days because it took me that much time to get into the court's docket. They gave him the 2 days. They stayed the other 18 days.
So I guess my question is this moot because he has served the sentence at this point?
I don't think so. Well, he didn't ask for a stay, but it was obviously not voluntary that he go to jail. The judge was very upset with him. That's why he put him in jail. I don't think it's moot because on the judge's sheet, he gave him an 18-day, what do they call that? Not a stay, but he put 18 days on the shelf for him, let's say it like that.
So he served 2 days.
2 days.
Of his original sentence, and then
Uh-huh.
you came in and filed the motion to mitigate and got him out.
Yeah.
Okay.
Yeah. And there was no time to ask for a stay because he'd already served his 2 days. And then I think his stay of 18 days was even up by the time we filed or close to being up by the time we filed the appeal.
So is there some sort of condition, like how would the 18 days come back into play?
I think if he'd gotten any type of violation or anything like that, or anything, a judge can violate you. It's not like being on probation, I guess.
Well, counsel, wasn't there, previous to the sentencing hearing, weren't there orders for him to mitigate the property?
Yes.
And had he done that?
He thought he had.
But-
And there was a big misunderstanding between him and the judge. He thought that the judge was saying one thing, and he thought that, I think the fencing, a better fencing, and something about a path. I think that's all he thought that the mitigation was, because he had all of his material there that he was working on 3 other buildings on. He was the contractor there. He's not the owner. He makes a big point of that, and that he's not the owner. It's been sold to a trust. He is a member of that trust, but he
He's a
doesn't have-
beneficiary, right?
Beg your pardon?
He's the beneficiary of the
He was
trust?
one of the beneficiaries of the trust. I don't think he's the trustee who really would be the decision maker, who would be in charge of the property. So that's a bone of contention too.
That these 18 days that are on the shelf?
Yeah,
Would be imposed if he did not fully mitigate the property concerns?
that could have been, the judge can, my understanding is, it's like probation. You can violate, anything you do, you can violate.
Well,
He did
usually,
not
but
file.
with probation, there's like rules.
Yeah, the
and
rules.
There's like, if you don't comply with this, here's the consequence. That's what I was trying to figure out. Like,
Right.
is-
I looked at the judge's sheet. You've got the judge's sheet. I know.
I mean, I can't even interpret what this says.
That's a typical judge's sheet in municipal court, Your Honor.
I need my magnifying glass.
That is typical.
But did the court say anything? Did the court impose any conditions?
I wasn't there, Your Honor, and unfortunately, I just noticed this I was working on this all yesterday afternoon. I hate to get too prepped too early, hate to peek out, but I noticed that they put the transcript for the trial, they put the transcript for the sentencing, but then I think there was another sentencing after that there's no transcript for. It's just the judge's sheet. That's my understanding. I think,
Another sentencing before the motion to mitigate, is what you're saying?
No, yeah, yeah. No, there was another, I think he actually put him in jail, and that's part of what we're getting at here, what the judge's terms were, et cetera. And because I could tell by the transcripts that, there's the big trial, then there was a matter of time, I think on the 20th he was actually sentenced, but I think there was another sentencing on the, a hearing on sentencing prior to that even, and that's a transcript. But I think of the 20th, I don't think there was a transcript of the 20th. If either the clerk missed it or...
Was there a hearing on the 22nd on the motion to mitigate?
Yes.
So what happened at that hearing?
Not much. There's no transcript of that either, I don't believe. But at that time, I just filed it, and the judge let him out of jail. And but did the I think you can tell by the judge's sheet, that's where he put I think the 18 days.
Right.
And
But
it also
it says like fence and maybe container storage. I don't know. Like, I don't know if those are conditions or some sort of requirement. I can't make out the first word or the last.
paving. I think that's the paving that he thought he was supposed to do.
Okay.
That there's what he ended up doing with that lot, and the last I saw it looked really nice. Was he put paving stones all in it, and he's building a walkway, and then there's going to be an apartment on stilts like that they can park under. So it's paving stones, and I think that's the paving and the fence. And but the contractor storage was the big problem, his equipment, et cetera. I also don't think it's moot because of the reputation that he has. He is a contractor, and for him to look like he's violating building codes or zoning codes is damaging to his reputation, and therefore I think it's not moot because of that. And I think this not asking for a stay stuff is kind of it's not proper due process either. It's automatic in felonies, I see, but not in misdemeanors. It's kind of a catch-22 for misdemeanor people, I think. I don't.
Well, but I think that's why we've
good.
been. I think that's why we've been clear in our case law about the requirements to avoid people not being aware of these issues.
Yeah, I wasn't aware of that. I admit it. And my client sure in hell wasn't aware of that. It's just like this ambiguous statute they've got. It is impossible to tell. And the only person that knows you're in compliance or not in compliance are the inspectors. They're the ones that can tell you. They say it's not a contractor yard. Contractor yard has to be this, and this, and this.
I thought you had to get a permit or something to have a contractor.
Well, he thinks that he had it from years and years and years ago because
Yeah, but there was no permit. There was no permit that was in evidence, right? At trial.
The state didn't show one, but
Well, whose
but he's
obligation
been
is it
there.
to-
He's been there since I think he showed a picture back from the 80s or
Right,
90s.
you showed a picture. But whose obligation is it to show that he had a permit, that it was a prior non-conforming use? Is it
I
his
don't
or
know.
the state's?
Well, it's like if I put asbestos in my house, there's no permit for that, right?
Mm-hmm.
But they grandfather it. They don't make me come and tear the asbestos out.
But
The
isn't
same
this a
way back
different
in the day,
situation, though?
You had storage there. Beg your pardon, ma'am?
Isn't this a different situation, though?
No, I
To
don't
be able
think-
to use it as a contractor storage, there were certain things he had to do?
No, I don't think so, Your Honor. I think it's the same as, the things that were not in the building code that are in the building code today. And then you step up and say, hey, this is not in compliance with the building code today. Well, hey, hold on. I built this in 1700. So, yeah, no, it's not going to be. It's going to have asbestos, and it's going to have this or that in it.
Counsel, is the non-conforming use issue, and this really isn't addressed in either brief, but is it more like an affirmative defense where the state would be saying there's a zoning code violation, this particular use is outlawed by our zoning code, therefore there's a crime?
Right.
And then the defendant would come forward and say, wait a minute, this is a non-conforming use. Is that like an affirmative defense?
Yeah.
Or does the state have the burden to disprove the existence of a non-conforming use as part of its case? Which one is it?
That's a good point, because we got to remember, this is a criminal action, so it's got to be proof beyond a reasonable doubt. There's a doubt that he had this prior use. Yeah, there's a lot of doubt here.
But if
There's a
it's an
lot of-
affirmative defense, then it's the defendant's obligation to come forward with that.
I've never seen it raised as an affirmative defense. I'm sorry.
I think that was Judge Kinsley's question is it an affirmative defense, or is this something the state had to disprove as part of their case in chief?
I think you hit the nail on the head, Your Honor. I think, criminal don't have any obligation to prove anything.
Well, but
except
think about like duress. You say like, you shot this person and say, well, no, I did it under duress. That is an affirmative defense. The defendant then has to prove that. Like, the state doesn't have to disprove that.
Well, certain way.
So I mean, it's just a type of affirmative defense.
I know the one is self-defense. It's an affirmative.
Well, but
defense.
that's
Has to be
changed by
raised for-
statute because they just switched the burden to the state now.
Yeah.
Previously, it was on the defendant,
Right.
like other affirmative defenses.
I didn't see any case law on this one, so I'm sorry. But it's something, this man, and the sad thing with the backstory of this.
And just to let you know that you are at your time if you want to reserve some time for
Okay,
rebuttal.
thank you, Your Honor.
Okay.
Good morning, Your Honors.
Good morning.
Opposing counsel, may it please the court. Mr. Stevens' conviction under 145109 was not against the manifest weight of the evidence, but additionally, it is moot, and I'll address the application.
Can you interpret the judge's sheet for us?
Yes, Your Honor. I think Mr. Hoyt is correct that the first thing, it does say paving, and
Okay,
there
that's
is
paving, okay.
fencing,
Right,
container or contractor storage.
right,
I can get you about halfway there on the fourth item.
okay.
Yeah, I think it says zoning is
Comply, maybe?
comply zoning. I think that's correct. But I think to answer your questions about what occurred and maybe some of the procedural posture, I think I can clear that up for you. So there was, I think, an early August of 2022 report setting, at which point you have the transcript for that. And Judge Bouchard, who wasn't the trial judge since he was out, admonished Mr. Stevens to bring the property into compliance by September 20th. There is no transcript for the September 20th hearing, and then there's no transcript for the September 22nd hearing. It is Mr. Stevens' burden as the appellant to file portions of the transcript that he may consider relevant to his case. So if there's not indications in those portions of the transcript that he asked for stay or didn't acquiesce pursuant to the Lewis test, that weighs against him. I think when you look at the procedural history of this case, the court can see there was a January 2021 trial date. Mr. Stevens did not appear for a year and a half. Mr. Hoyt talked about some medical issues today. I'm not sure if those were in the record, but I will say he was represented at trial, at the time at least. Or his counsel could have filed some sort of motion for stay or other post-trial relief, and that didn't happen in this case. I do think that it is correct that Mr. Nieberding, Mr. Stevens' trial counsel, had withdrawn by the time Mr. Stevens appeared in the summer of 2022. So Mr. Stevens was pro se at the September 20th and the September 22nd hearings. Or excuse me, not the 22nd. Mr. Hoyt was representing him by that point. I think the thing that stands out to me in the Chambers case is paragraph 18 that talks about the factual similarities where Chambers initially didn't contest the finding of the contemptuous behavior in that case, and there was no motion for stay. I think that's similar to this case. Like I just said, there was a trial and no notice of appeal until after the sentence. I think for this court's purpose for analyzing whether a case is moot or a person acquiesced, Mr. Stevens served the 2 days. It is true, he did have, I think, the 18 days, as Mr. Hoyt put it, on the shelf, but he didn't serve any more incarceration.
So, but then my question is, on the shelf for what? Like, how do we know what the details are related to that?
I think I'm not sure what would have been in the transcript, but this is a housing docket case. I think it probably is similar to what Judge Bouchard admonished him on August 2nd of 2022 to bring the property into compliance. The other deciphering I can help you with, Your Honor, I think it says on the top of the judge's sheet for October 25th on the stay on days setting, state satisfied. So I think there probably was discussion about the condition of the property. So I do believe, though, the procedural posture of this case demonstrates that Mr. Stevens acquiesced to his sentence and that is therefore moot.
You don't think a motion to mitigate demonstrates that he did not acquiesce?
No, and I think that is, again, from Chambers, paragraph 18. Counsel did argue for mitigation of the sentence before completion, citing hardship and remorse. Mitigation is not the same, or the equivalent for a motion to stay a sentence, and that's from this court's decision. So moving on to his assignments of error, I think it's important to clarify for this court's review what's not at issue, and that is the sufficiency of the conviction, the sufficiency of the evidence. Mr. Stevens' brief doesn't argue that this property was in a commercial community pedestrian district, that it was being used for contractor storage. In fact, Mr. Hoyt just said Mr. Stevens had materials he was using from other buildings at that location. Doesn't dispute that he received multiple notices from the Department of Buildings Inspections to cease that use, or that he didn't comply. So I just want to be clear. What we're talking about in this case is the manifest weight of the evidence, and that comes down to credibility determinations made by the trial court as to the evidence the state presented versus the evidence that Stevens presented.
Counsel, what about this nonconforming use claim? Is this part of your case in chief, or is this more like an affirmative defense?
Your Honor, that is more like an affirmative defense. I will say there's really not a lot of case law about zoning affirmative defenses. I did look for that issue, but I think either way it gets to the affirmative weight or the manifest weight of the evidence, and it goes to the credibility of the evidence. I think if Stevens had evidence that he thought tended to disprove his guilt under any particular statute, it is his burden to bring that evidence. The nonconforming use issues are not an element to 145109, failure to comply with a lawful order from the Director of Buildings and Inspections.
Doesn't this look a little bit different, though, than some other affirmative defenses in that the evidence that a defendant would need in this circumstance would come from the state? Assuming that a defendant could show a nonconforming use, they would need a permit or some kind of records about previous use of the property, and that would be in the possession of the state. Should we consider that at all?
I don't think you should consider it in this case, and I think there are parts of the record that show you why, is that the state did conduct a review of its system to determine whether there were prior nonconforming uses or lawfully established nonconforming uses at the property via review of its document system. So even though the state didn't have to in that case, I think they did go the extra mile to look that issue over before trial, and that's in the record.
So that was testimony at trial that they reviewed their records and they did not find any records of lawful prior use.
That's correct. It's on page 56 of the transcript. We could find nothing prior to 2002, or I believe it was 2000.
And that would be looking for a permit as well. I mean, that's what was needed, was a
Yes.
permit. Okay.
That's correct. That's also from the testimony of the two building inspectors that testified.
So nevertheless, the state did present that evidence.
Yes.
Okay.
So that is before the court. But I also think the other thing to consider, and the most important part for this court to consider about the prior use, is just the photos, States Exhibits 2 through 10, and the corresponding testimony that the absolute ridiculousness of the condition of materials piled on top of each other would show that it's not being lawfully used in a way to constitute proper contractor storage, that if Mr. Stevens had applied, and this is in the record, for contractor storage based on the condition of the property, he wouldn't have never gotten a permit. That contractor storage requires plans, means of egress. You can't just use it essentially as a dump, for lack of a better term. Moving on to the person in control part of the manifest weight of this case. Again, I'll repeat in my brief. I think his evidence corroborated that he's a person in control. And again, you heard it here today that Mr. Stevens had material there that he was using from other properties that he could have removed as use of contractor storage. It's true, the record says that he's a member of the trustee, or a member of the trust, not the trustee. But he's also the owner of a maintenance company that's located directly next door that has contracts with the trust to repair the property. So I think there's just tons of corroborating evidence to show that Mr. Stevens meets the broad definition of person in control for purposes of the zoning code, that he had the authority and the ability to abate the zoning code violations at this property.
If it was just that he was the beneficiary of the trust with none of the other stuff, is that enough? Or are we looking at all of the other evidence that he had control?
I think just the beneficiary, I'm not sure I have a good answer for that, Your Honor. I think in this case, I'd ask this court to look at States Exhibits 11 through 18. There's 30 years of his control over the property, and Stevens' own testimony that he's been trying to bring the property or renovate it for over 30 years. Finally, unless there's any questions on the constitutionality section of the complaint, I would happy to just submit on my brief for that. I think that's been forfeited for purposes of this appeal. Unless there are any other questions, ask this court to affirm.
All right.
Thank you, Your Honor.
So we're-
On the matter of,
we did take you a little over with our questioning,
Okay.
so I'll give you your 3 minutes.
oh,
Okay.
I'm sorry. On the matter of stay again, I noticed that I was just looking through my things. I had it somewhere, the actual line and page, but he did, here it is, on page 7, line 19 of the sentencing transcript, he notified the court he was going to appeal it. So to me, that's layman for putting the court on notice. He didn't have an attorney there, so I hope you bear with him on that. But I think that addresses somewhat on the stay. And in State v. Allen, there's a clause in there. They say, neither are we adopting a position at the other extreme that a constitutional issue first raised on appeal must never be considered. I think that addresses the mood issue. As far as the ambiguous statute issue, again,
Counsel, wasn't this just a typo? I mean, it looks like they cited section 19 and they really meant to cite section 20.
yes, it's true.
So
Yeah, that's what it looks like, but
How does
but
that?
that's the complaint. I mean, that's on the face of the complaint, too. But even dig deeper than that and start looking at those statutes. They, they're very vague. They leave so much authority to the inspectors. And that's where we get into these problems, that what can you do and what can't you do? And again, he's storing things there to fix the buildings. And I hate to say it, that, do you do what's right or what's easy here? this man's really trying to fix this place up. He's been working at it many years, and he's made tremendous progress compared to some of the buildings around there. Part of the building had even fallen down, so it was a mess, but he was working on cleaning it up. It just didn't, it's not like the factory down at Queen City and Harrison Avenue that's sitting there that's like 14, that's about 8 stories tall. It's been sitting there for years and nobody's touching it. And what is they doing? You know, what are they doing? This man is really trying, and he's been trying for many years. That's all I can do. Thank you, Your Honor. Thanks for your time.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. All right, the next case is Bauer versus River City Mortgage. And Mr. Haber, would you like to reserve rebuttal time?
About 5 minutes.
5 minutes, okay. Whenever you're ready.
May it please the court, my name is Rich Haber. I'm pleased to represent Alyssa Bauer with respect to her claims against River City Mortgage and Mr. Hunter. The issue before this court is a relatively simple one. Prior to filing an answer, the defendants filed a motion to dismiss and compel arbitration under Ohio Revised Code, Section 271101A. 271101A specifically provides that where a contract between the parties reflects an obligation to arbitrate, the court can compel arbitration. The issue in this case is simple. As the trial court actually correctly noted, we disagree with everything after that with the trial court. Specifically, defendants...
And was the motion simply under the Ohio statute, or was it also under the Federal Arbitration Act?
I believe it was just under the Ohio statute. Specifically, both the defendant appellee and the trial court seized on the public policy in favor of arbitration, which we acknowledge. There is a public policy in favor of resolving disputes in arbitration when the parties agree to resolve disputes in arbitration. The court then said this is a broad arbitration clause. We also agree, but it only matters if there's a contract between the parties to arbitrate. And that's where the defendant's argument and the trial court's decision fall apart.
And I assume your position is that nothing in the employee handbook is enforceable at all. Is that right? Or is some part of it enforceable?
Functionally, I agree with you that nothing in the employee handbook is enforceable as a contract because there is a very, very express and broad disclaimer that this handbook in its entirety is not to be construed as an express or implied contract and creates no obligation on the part of the company. The case law in the First District is clear that when you have a broad disclaimer such as this, an employee handbook is not contractual. Now, that case law developed as plaintiffs were using handbooks to create contractual claims, promissory estoppel, implied contract. And the courts all very clearly and uniformly said that where employers disclaim contractual obligations in the handbook, no contractual obligations exist.
Obligations of the employer, though.
But in order for arbitration clauses to be enforceable, there has to be mutual assent. And the case...
Your client signed an acknowledgement form.
An acknowledgement form that says she had read and understood and would comply with the policies, but the disclaimer specifically gives the employer the right to modify at any time without notice any of the policies.
So if it were the same factual scenario, but the employer had required her to sign a separate document, you know, a paragraph that says, I hereby, as a condition of my employment, agree to arbitrate any disputes, that doesn't make reference to the employee manual, would that be enforceable?
Yes, Your Honor. In fact, there are two cases that specifically stand for that proposition, which we referenced in our brief. One is Cunningham Malowit, and the other is Coral versus Thomas King. What they do is they clearly explain how employers can make an arbitration clause in an employee handbook an enforceable contractual obligation. All of the cases we've cited stand for the proposition that, one, the disclaimer makes the employee handbook not a contract, and two, in the context of arbitration, where the employer reserves the right to modify the handbook at any time, there's no mutual assent, and the arbitration clause is not enforceable. In Cunningham Malowit, there was an acknowledgement form for the employee handbook. It was silent as to the arbitration.
Was there a disclaimer on that?
There was a disclaimer exactly
Just
as
like
in this
this one?
case. Yes, but the
Okay.
distinction between Cunningham Malowit and this case is there were two acknowledgments signed. The first acknowledgement, which had, and the handbook had a disclaimer, said nothing about arbitration, and the court said that the handbook itself is not an enforceable contract based upon that acknowledgement. The court then went to the next step and said, but she signed a second acknowledgement, and that acknowledgement said, I acknowledge that I've read the policies and I will comply with the policies, and I will be bound by the arbitration clause in the handbook. The court found that second acknowledgement to be an enforceable contract. We don't have that here. The Coral case is similar. In the Coral case, the employee initialed next to the arbitration clause, and there was a specific statement in the acknowledgement that the employee was not just acknowledging receipt of the handbook and an understanding of the policies, but that the employee was agreeing to be bound by the arbitration clause. Those two cases are very different from the facts in this case. Every single case, state or federal, in Ohio, that has addressed the issue of facts identical to this has concluded that the arbitration clause is unenforceable because there's no mutual assent, because the employer reserved the absolute right to modify the agreement, and the employer specifically said, this is not a contract. Every single policy in the handbook, to Judge Bergeron's comment, is not a contract, express or implied. You have to have mutual assent. The defendant's argument that we have consideration is irrelevant because consideration is only one element of a contract. Mutual assent is another. Our arguments have all been focused on mutual assent. But on top of that, every employee relationship in Ohio, the overwhelming majority of employee relationships in Ohio are at-will employment situations where you have consideration and employers, in most cases, provide employee handbooks to their employees, and they contain disclaimers. And even though you have consideration for employment, you do not have contractual obligations created by those employee handbooks. That's the issue in this case. Was there an agreement to arbitrate? It is
Counsel,
not enough to acknowledge.
Section 1, the welcome message, which is literally the first page of the manual, says this manual is not a contract expressed, which I think is a typo, or implied. And your client, in signing the acknowledgement form, said she'd read the manual.
Sure.
So,
Well, I don't know that she actually did, but in signing it,
fair enough,
Right.
fair enough. Some people don't read what they've signed. But
happens all the time.
if she had read it, and this is on the first page, so that might have been something that she would have at least seen or skimmed.
She would have understood that the handbook was not a contract.
It's just workplace rules or something to that
In
effect.
fact, it says that. These are guidelines, and they can be changed at any time. Handbooks are intended to provide information to employees to provide some expectation, but not contractual obligations. Though employers can create contractual obligations for handbooks. They can make the handbook a contract. They choose not to because they don't want to create liability arising out of failure to follow their progressive discipline, for an example. This handbook is a very, very substantial document. It had an arbitration clause in Section 8 that was nondescript in that it was contained on the same page as other policies. They specifically and very broadly disclaim the contractual implications of this employee handbook. And they very simply could have resolved this issue by having a statement in the acknowledgement that says, while the handbook is not a contract, you acknowledge and agree to be bound by the terms of the arbitration clause, which is contractual. That sentence alone would have solved this problem. It didn't exist in this case.
In theory, let's play this out, and I realize some of what I'm about to say is maybe not realistic in certain employment contexts, but in theory, an employee could read over a manual, and if they don't like certain provisions, they could go back to their employer and say, hey, I'd like to negotiate, different rules, different start time of my day, different expectations about my roles and responsibilities. I don't like this arbitration clause. Can we take that out? But your client, being confronted with this, would have been given the comfort of not making that negotiation by seeing this term, this is not a contract, right?
If you were, in fairness to my client, if you were to attribute that type of sophistication to her where she read the entire employee handbook and was concerned about a particular provision at that time, she could have gone and said that I'm concerned about these, but it would have been unnecessary having read the introduction that this is not a contract for employment, it is not an obligation by the employer, and if she had the sophistication to understand what was necessary to create a contractual obligation, that disclaimer both at the beginning and at the acknowledgement, it wasn't just in one place. This disclaimer it screams to the employee, look, this is not a contract. And until they can show that it is a contract, there's no enforceable arbitration clause. I see that my time is
You're at your
up.
10 minutes if you want to reserve
I
5.
will reserve 5 minutes. Thank you.
All right, thank you.
May it please the court. I am Tim Owens. I'm here on behalf of the defendant appellees, River City Mortgage and Nicholas A. Hunter. And frankly, I agree with almost everything my opposing counsel had said, other than I believe there is a contract. The contract.
So let me stop you there. What is the contract?
The contract.
What in the employee manual is enforceable contractually?
It's a contract for employment of at-will employment with the conditions stated in the employee handbook as
So everything in the manual is a binding contract?
stated, subject to the conditions in the employee handbook. It's no different than if I have a client.
Well,
sign-
but the conditions in the employee handbook say it's not a contract.
I can have a client buy a business, say, I have the absolute right to get out of this contract if certain contingencies don't apply.
Right.
And that's still a binding contract on the seller and the buyer. That's no different here. You are getting employment in consideration for at-will employment, no specific period of time. And that's actually what the disclaimer says. In section 1, it says it's not a contract, express or implied, and there is a typo, guaranteeing employment for any period of time. And that's the same language essentially in section 9, except there it says for a definite or specific period of time. And that goes back to MERS v. Dispatch Printing Company when I was a young associate and all I had to do was research and write. But employers were worried about the contract as a whole. If there was something that said, after 3 years you'd vest in the employee benefit plans. Well, now I have a contract for 3 years. That was what this disclaimer language was meant to get
Well,
around.
right, but I think there's just like a fundamental inconsistency in saying this is a binding contract when you've told the employee it's not a binding contract, and by the way, we can change it, at our own prerogative.
Correct.
So I just am having difficulty understanding, I'm an employee who applies for a job there, gets a job, I read this manual, and it says, I think a couple different times, this is not a contract. I'm supposed to walk away from that knowing that it's a contract?
But the language is more, the disclaimer language isn't as broad as plaintiff appellant would make it. It's disclaimer language to disclaim employment for any period of time. And I think that's a key distinction. And also, I think it's similar to, there's case law precedent to support. I'm an employee. I haven't signed anything. I just went to work with the employer, and they hand me a non-compete agreement 3 weeks into my employment, and I sign it. And I argue that when I don't want to be constrained by it, that it's not enforceable because there's no consideration. The courts are unanimous in their precedent that every day of
Well,
continued
let me
employment.
go back. You said that the disclaimer language is specific to a definite time of employment, and it does say that, but it also says, or to otherwise create, express, or imply legally enforceable contractual obligations on the part of the company concerning any terms, conditions, or privileges of employment. So doesn't that then say nothing in here is enforceable?
It could be construed that way, but again, I believe that it goes back to the contingency analogy that I use with buying a business. One side in a contract can say, I have the absolute right to change this if something happens.
Correct, but those contracts, I mean, there's contingencies, and it allows a party to escape the contract if that contingency comes to pass. Otherwise, it's enforceable.
Correct.
This looks different to me because it doesn't say if this, then the contract's not enforceable, or this allows one party to leave and the other one. This just says this is not enforceable.
But nothing changed in the handbook. The arbitration provision was enforced, it was there, she read it. And going to the second point, and the Malloy decision, if I'm pronouncing that correct, Cunningham, what we have in this case is the exact opposite of Malloy. If you read Section 8 of the Employee Handbook, which is the arbitration provision, that provision specifically references the acknowledgement. And it says, we've attached this, please sign it. And it's directly after Section 8, because Section 9 is the acknowledgement form. So while they're still in the same document, there's specific direction that I've read the arbitration provision, and the next thing is I'm acknowledging that I've read it and I agree with it. And I think that's Malloy 180 degrees inverted, but the same factual situation. They have a specific carve-out within the Employee Handbook, Section 8, arbitration, here's how it applies. Section 9, the next provision, says I acknowledge and I agree. And the J.D. Byrider case, which goes back to...
So let me ask you this, because the manual allows the employer to change the provisions, she sues you, you go to arbitration, it gets enforced, and now you decide you want to change the arbitration provision to require her to, pay all the fees or to pay your fees. Like, you could put those provisions in a contract. So is she then bound to that?
No, and I think the Byrider case...
So why not? Why not?
Because the Byrider case specifically stated out, this arbitration provision says the arbitration is going to be under the AAA rules. And like my client, they're a sophisticated client, but they can't get AAA to change their rules.
Well, then why wouldn't they say, now we're under the P rules, some other arbitration organization that's different? Like, could they not do that?
Prior to, but as Byrider said, once the arbitration has been invoked, we can't change the rules because we don't control the rules at that point. AAA says if it's employment arbitration, these rules apply. Right. And we even have the shifting fees provision in our arbitration provision. So we've complied with AAA, and I think the key distinction here is if you buy that the disclaimer is broader than I would like it to be construed as, more than just employment for a specified period of time, then the fact that the arbitration provision in Section 8 followed immediately by the acknowledgement form, and she may not have been sophisticated enough to read it, but the law in Ohio and pretty much everywhere, I can't speak to California, is if you're presented with something in writing and you sign off that you've read it and you understood it and agree to be bound by it.
But can I ask you, in one of your answers to Judge Bergeron's questions about this language that says it does not create, express, or implied a legally enforceable contractual obligations, and you answered, and he said, well, doesn't that show that this wasn't a contract? And you're like, well, it can be construed that way.
Yes.
I thought I heard you. I mean, if it can be construed as not being a contract, then how do we have a meeting of the minds here?
Because the case law that developed after MERS basically stands for the proposition, and the case is cited in this brief by both sides. What we have is a contract for at-will employment, no specific period of time, with certain terms and conditions that apply, which are contained in the handbook. And every day that she came to work and there have been no changes in that handbook, the same contract applies and it goes forward. And there's,
But it could be, I thought you meant in answer to his question, and maybe I misunderstood, that this language could be construed as saying this is not a contract. It's ambiguous.
I can see that. And I did not draft the handbook, but
Sure.
I'm not blaming the
Not
person
blaming
that did.
you.
Yeah.
But, I mean,
But
it seems like, it's very ambiguous, and I don't know how you say that that's a contract and that's a mutual agreement.
Which is why I think the most important point of this is to look at Section 8 and 9, which follow each other. And it's a separate policy, and immediately thereafter, there's an acknowledgement form that says, I've read everything, including the policy immediately above it, and I agree, and I'm going to be bound by it. And again, it goes back to, if you presented something in writing and you sign it, you're presumed to have read it.
It almost seems like a gotcha arbitration clause, because it's not, this language could be construed as saying this is not a contract, and it's not explicit in the acknowledgement part that she's agreeing to arbitration.
But their employers are allowed a certain amount of latitude with gotcha. The example of the non-compete agreement. 3 weeks in, after you've signed the employee handbook, I come up with something else, no change in your conditions of employment, and say, sign this or I'm going to fire you.
But you
Employers are
sign
allowed
a
to-
separate agreement in that circumstance.
Yes, it is a separate agreement, and that's why I think 8 and 9 read
Counsel,
together.
let's put the shoe on the other foot, and
Okay.
let's say that your client, the employer, is the one suing the employee, and the employee wants to trigger this arbitration clause. In that circumstance, under this document, your client can just change the arbitration clause if they don't want to go, right? Because this document allows the employer to just change the terms whenever they want. And if your client wants access to a public court rather than a private arbitration, you get to unilaterally decide that.
I don't think we get to unilaterally decide it. Let's say that the shoe truly is on the other foot, and we sue Mr. Haber's client, and they they file the motion. I don't think I can change it at that point.
Why not?
Because at that point, the contract's in place. What the court is looking at can't be changed at that point,
Why not?
because the court has taken jurisdiction over the case.
Where would we find that in this document?
It's not in the document. It's just, I hate to say this, but common sense. I can't present a motion to you and then 2 weeks later change the underlying facts and still have you rule on that motion. You have to rule on the motion based on the facts that are in front of you at the time, which is what happened here. That was a policy. It hadn't been changed. We sued to have the case moved to that type of arbitration, and that's what was before the court.
Well, what if, I mean, building on Judge Kinsley's hypothetical, what if it was, misappropriation of trade secrets, you're going out, you're stealing clients, you're doing something like that, and the employer sues the employee here, and the employee says, I'm going to go to arbitration. Like, is the arbitration clause enforceable in that circumstance?
I believe it would be.
Okay.
And then would have to rely upon the AAA rules for employment arbitration to see whether there's any equitable relief that we could obtain under that process.
If the terms of this document, the manual, are changed, short of litigation, just in the normal course of business, how would an employee become notified of that?
In the old days, there'd be something in a pay envelope, at least that's what I would suggest. In the current days, it gets updated on the company website, and they're required to stay up to date on that. And it's a problem for employers because the wholesale revisions of Chapter 4112 2 years ago. I mean, a lot of things get changed.
So they don't have to they don't have to sign a new acknowledgement form every time there's changes that are made?
In a perfect world, they would.
Oh, okay.
And if there are major revisions, they would, and I typically recommend that it's done in conjunction when somebody gets an extra paid holiday or in their annual review where they get a raise, so there's no argument about consideration. So, you know, hypothetically, the best practice is to do it in a way that there's no dispute about it.
But that's not legally required?
I don't believe so, no. That is all I have unless there are any other questions.
No?
Thank you.
For your time and attention.
I will be very brief.
You have 5 minutes.
I
You
will not
reserved.
take 5 minutes. I won't say I promise.
Don't ever say that.
First, this non-compete issue has nothing to do with this case. He's talking about a separate agreement. But probably the most important concession, and while I think it's very clear that this is not a contract, his concession that it could be construed as such admits to this court that there's ambiguity, and they're the drafters of this agreement, and any ambiguity has to be construed against the drafters of this quote agreement, which means if you construe the ambiguity against the defendants in this case, there's no enforceable arbitration clause. As Judge Kinsley asked, if the shoe was on the other foot, could they decide not to go to arbitration? Let me change the facts a little bit. If they file suit against my client, he says they would be forced to go to arbitration because it's in the manual. If my client files suit claiming breach of contract based upon the manual because you didn't follow the progressive disciplinary policy, what is their response going to be? It's going to be, it's not a contract. There's a disclaimer. And the first district jurisprudence will tell you that he will win on that. So if he files suit in state court against my client for trade secret violations, and I file a motion to compel arbitration on the basis of an employee handbook where there is a disclaimer saying it is not a contract, his defense to that claim will be identical to a claim for breach of contract or promissory estoppel that I might assert. That is, it is not a contract. We have a disclaimer, and the first district jurisprudence says I win. There is no contract, and even if you accepted his position that it's ambiguous, we still win. And so with that, if there are no further questions, I will sit down. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision.
Thank you.